Yes, Counsel.
Yes, Your Honor, we raise this issue under the Civil Procedure Act, Section 64E.
Section
64E of the Civil Procedure Act, and under Section 98 of the Civil Procedure Act.
Yes, Counsel.
Your Honor, this under Section 64, in order to prevent the ends of justice from being defeated, this court may make such other interlocutory orders as may appear to the court to be just and convenient.
Court may
Make such other interlocutory orders as may appear to the court to be just and convenient. Section 98, which saves the inherent powers of this court, we submit that this court has inherent powers to make such orders as may be necessary for the ends of justice to prevent abuse of process. Your Honor, Section 74 subsection 2 of the Parliamentary Elections Act provides that the Chief Magistrate shall appoint the time to recount the votes with the votes which time shall be within 4 days after receipt of the application, like the one before you. Your Honor, Miscellaneous Cause number 1 of 2026, the instant application was filed on the 20th date of January 2026. Our quick count, Your Honor, the 4 days ran from 20th of January to 23rd of January, which was a Friday. It was filed on Tuesday 20th, day 1, Wednesday 21st, day 2, Thursday 22nd, day 3, and Friday 23rd was the 4th date. We submit that this Honorable Court has no jurisdiction to perform any act beyond the said 4 days. Your Honor, this matter has been determined. In revisional application number 2 of 2023, you'll find at page 6,
number 2
of 20. Wait, let me first use this. Okay. Revisional application number 2 of 2023, arising from miscellaneous application number 2 of 2021 and miscellaneous application number 3 of 2021.
miscellaneous application number
2 of 2021 and the miscellaneous application 3 of 2021. Themselves arising from miscellaneous application number 2 of 2021 still.
Which one did you mention as 2023?
2023 is the revision application.
Revision application number
2 of 2023. Application number 2 of 2021 and number 3 of 2021. The same also arose from miscellaneous application number 2 of 2021 and civil appeal number 4 of 2021. Civil appeal number 4 of 2021, all arising from miscellaneous cause number 6 of 2021 of the Chief Magistrates Court of Masaka at Masaka. Number 6 of 2021. Yes, Your Honor, this was a matter, a revision arising out of an application for recount which had been won by the applicant, Sempija Vincent Radio. It had been won by Sempija Vincent Radio against the Honorable Katabazi Francis Katongole. On revision, the Honorable Katabazi Francis was the applicant, and the applicant before you was the first respondent with the Electoral Commission and Returning Officer. When such an issue on computation arose, the Honorable Justice Lawrence Tweyanze, at page 6, paragraph numbered 17, gave the details of the date when the application was filed. That application had been filed of recount, had been filed on the 20th of January 2021 in miscellaneous application number 6 of 2021. The judge went on to find that the application was received on the 21st of January 2021, and on computation you will find as highlighted that having filed the application on 21st, the days lapsed on 24th of January. And for brevity,
the
days having filed on 21st, the days had lapsed on 24th of January 2021. Thus, within 4 days meant that the date of receiving, from the date of receiving the application, meant even the date of filing. And that is the 21st, 22nd, 23rd, and 24th. In the instant case, it is the 20th when they filed, the 21st, the 22nd. For clarity, the last day, under 17, the line 1, 2, 3, 4, 5, 6, 7, 8, 9, the 9th line, for clarity. For clarity, the last day was 24th of January 2021, thus within 4 days from the date of receiving the application, which meant even the date of filing, thus 21st, 22nd, 23rd, and 24th. Court found that clearly ordering a recount to be done on the 26th of January 2021, which was beyond the statutory required days, was in violation of Section 55(2) of the Parliamentary Elections Act. It's our submission that, which is now 74(2). It is our submission that this instant application having been filed on 20th, the days within which it could be disposed of, including any orders lapsed on the 23rd of January 2026. This matter, which involved the applicant, was not appealed against. It remains a binding authority on this court. In the premises, we humbly pray that you find that it would procedurally be improper and wrong at law to proceed beyond the said statutory required days, as it would be in violation of Section 74, subsection 2, the Parliamentary Elections Act. We are most obliged. It's our prayer that any matter outside may not proceed. We are most obliged.
I strongly do not agree with the interpretation of the law and its application to the fact of this matter. I take the view that this court is still acting in time in handling this matter. Your worship, you are in time to deliver a ruling and not outside as alleged by the applicant. I will start with the law. Your computation of time is a matter our procedure law provides for. When you look at Order 51, the Civil Procedure Rules, Order 51, Rules 1, 3, 8, clarify the position of the law. Rule 2 says in computing exclude Sundays. Your worship, Rule 3 says when time expires on a Sunday or close of day, you consider the following day. Worship, Rule 8 says consider the following day. Rule 8, which is most applicable in the instant matter, and I'll read it because it is very critical. It says, in any case in which any particular number of days is expressed to be clear days or not expressed is prescribed under these rules or any other order or direction of the court, the days shall be reckoned exclusively of the first day and inclusively of the last day. This being, the date of filing is not reckoned in computing the 4 days. Your worship, my colleagues did not cite to you any statute. I have cited one. Your worship, the Interpretation Act, I pray you look at section 34 subsection 1A of the Interpretation Act. It also provides for computation of time, which my colleagues have not read and considered.
Interpretation Act, section what?
Section 34, subsection 1A. My colleagues have not read it. It says, in computing time for the purpose of any act, I would say substitute for the Parliamentary Elections Act, a period of days from the happening of an event or the doing of any act or thing shall be deemed to be exclusive of the day in which the event happens, or the act or thing is done. Now, the High Court has interpreted the computation of days for a recount. In the case of Saleh Kamba against Namuyangu Jennifer Byakatonda Yoshi, it is High Court of Uganda Timbale, Civil Appeal number 19 of 2011.
Kamba versus what?
Kamba Saleh against Namuyangu Jennifer Byakatonda, Civil Appeal number 19 of 2011. Yoshku, court considered the provisions of the law I have cited and the provisions of the Interpretation Act and held firmly that the day of receipt that the day of reception is excluded in computing time. The date of receipt of the application of the vote recount is excluded in computing the 4 days. So, Your Worship, I pray that you consider this one as times what my learned friends are interpreting as limited in time is not correct. Your Worship, I'm also going to cite for you two authorities of the Court of Appeal. The first is Kasivante Moses against the Electoral Commission. It is election application number 7 of 2012. The second Kasivante Moses against the Electoral Commission, election application number 7 of 2012. I think one is enough because they are repeat the same thing. The Court of Appeal held that in computing the 7 days within which to vote, also and this is an election matter, Your Worship, you exclude the date of the judge. Exercise the provisions of Order 51 Rule 8, the provisions of the Interpretation Act, that the first day is excluded. When you count the days, excluding the public holiday of Monday, yesterday, and the weekend, the 4 days in the extra today, I invite you to so find and overrule the erroneous submission and objection by my learned friend.
Yes, Your Honor, a recount, an application for a recount is a segment in election exercise. It is a duty performed by a court, but in an election exercise. In an election exercise. This time it would be court counting. Segments, again in Kasibante, segments in election exercise are very specific. Voting, counting. It is misconceived to consider it as a court process. It's misconceived. To bring it within the realms of an ordinary court process, filing a civil matter, hearing it, appealing against it. It is a process, an election process. It is the reason that Council has not cited any case which was interpreting Section 74. The segment...
I object to what my learned colleague I've cited the case of Saleh Kamba against the Namuya Jennifer. It interprets Section 74 and a public sentence of 4 days. So to allege otherwise is unprofessional. Should not do. Maybe you should read it and find clearly what it says. I would not allow that to go.
I don't know if it is, I don't know what it is. And I don't think we shall proceed like that. Yes, Your Honor, Kamba Saleh and Namuyang was not an application like the one before you. It was not an election exercise. It was a petition in court. Beyond the exercise which closes upon gazettement. The implication of an application for recount is that it interferes with the process. That is why upon an application, transmission of results is stopped. It's a segment in the election exercise. It is not a petition. So it was not in that context that Kamba Saleh and Namuyang was interpreting. And on this matter, Section 74 is self-contained. You need not look elsewhere in the Civil Procedure Act. Section 74 is self-contained. Issues of lodging a notice of appeal are matters of court process in a petition. And this is not my finding, it's a finding of a court of record. Specific on counting days. This was not the issue in Namuyango and Kamba Saleh. So it's our prayer that you find that the decision of the High Court by the Honorable Justice Lawrence Tweyanze was in pari materia. It was in pari materia and similar to the issues on all fours before you. It would have a more binding effect on this court than the cases so cited. We reiterate.
It was also the issue of the 51 about a Sunderland man.
The Order 51 does not arise of the CPR. The statute provides for days within which any action has to be taken in an election exercise. The Election Act, providing for the elections, states the days within which you cannot postpone unless the Electoral Commission, for example, postpones an election. If an election date lands on a public holiday, the election will go on. You will not say that the date fell on a Saturday, we shall not do elections. It's an election exercise. So it's misconceived to mix ordinary court process with an election process. An application for recount, it's both substituting electoral commission to recount. Submit therefore that election-related matters being self-contained, the interpretation by the Justice Flores Koyanze is the proper position of the law. The proper interpretation is on all fours with our submission, and we pray that we find that this honorable court does not have the jurisdiction sitting in an election exercise to adjourn a day beyond the 4 days in which an act has to be performed in an election exercise adjudicated by court. The most obliged.
Okay, thank you. Before I proceed to read a ruling on this matter, I want to begin by appreciating this team of lawyers. It is always bad practice to give recommendation when the person is born. I want to appreciate ruling of matter. It is not every lawyer that can sustain this kind of argument, and I want to appreciate you for that. And so so thank you. So this is my pronouncement. Not because you are for your clients, but I've had the privilege of having many lawyers for me. So this is the ruling. If I was to have a lot of time, I would equally write and read, but you know we are working about time. Even what is being questioned is what? It's time. So if I was also to write, or if I was given time, I would equally write and say, okay, this man can also read and write. But in the interest of saving and giving time, this is my pronouncement. I have carefully listened to the submission of Counsel Samuel Wizi for the respondent. And the response by Counsel Kasangaki, and the response by Counsel Kasangaki, and thereafter rejoinders. I wish to begin agreeing with Counsel Samuel Wizi that electoral laws are indeed self-contained, and before resorting to other laws and case law, the applicable act must be interpreted first, exhaustively, and if no remedy is provided, then we can stretch other statutes and case law. The issue beforehand, as advanced by Counsel Samuel Wizi, is that the court has since lost jurisdiction to deliver a ruling since the 4 days have since expired, i.e. having expired on 23rd. His argument is that the matter was filed on 20th January 2026, and counting started with 20th, i.e. the day of filing, and therefore 4 days had expired on 23rd day of January 2026. In reply, Counsel Kasangaki strongly objected, citing Order 51 of the CPR, Rule 1, Rule 3, and 8, which exclude Sundays when time expires on Sunday. And the law suggests that you consider the next day. In this case, the next day was Monday, but a public holiday on Uganda calendar. This means that actually the next available day was today, Tuesday. Without prejudice to Counsel Kasangaki Samuel, as regards to computation of time under Section 74, subsection 2 of the Parliamentary Elections Act, I want to quote it and read it as is, and I want us to interpret it together. Section 74, subsection 2, the Chief Magistrate shall appoint the time to recount the votes, which time shall be within 4 days after receipt. What does after receipt mean? You may not answer me. Yeah? Yeah? The Chief Magistrate shall appoint the time to recount the votes, which time shall be within 4 days after receipt. So this basically means, without even going to your laws, without even going to your cases you have cited, the law which Counsel Samuel Wizi rightly cited as self-contained has a solution in this, because it is guiding us that the 4 days expires after filing, meaning that the date of filing is not included in the 4 days. You will read it further, but I wanted us to pause it and share about that. 4 days after receipt of the application, court's interpretation of the very self-contained subsection of Section 74, i.e. Section 74, subsection 2 of Parliamentary Elections Act, is that the days mentioned in the law started counting on 21st January 2026, and therefore I find that it is not true that the days within which to deliver a ruling had expired on 23rd January 2026 as counsel Muizi for the respondent with which this court to believe. Therefore, I find that this court is still within time prescribed by the law, within which order for account, and therefore I proceed to deliver the ruling. I'm still having time. Oh. Sorry. So allow me to proceed and read the ruling. We are working, this is the last day. This is the last day. But before I read the ruling, you campaign. You campaign. If these voters told you lies, or told you the truth, if at all, I want to say it here, like I said it then, and I want to repeat it here. If at all your victory is kept, or was reflected in ballot papers, as long as there is no tampering, as we may wish to believe, because as long as there is tampering, I can't go ahead to count, even if I order a count, even one box. Then if there is one tampering or tampering of one box, I can't go ahead and count. Why is it that candidates, you don't want to see what is there? Is it that all your hands are dirty? Is it that you want to maintain victory as of now? Because if somebody is satisfied as now, it means now it's going to take you to a petition. And a petition requires that somebody should be gazetted first. Why should you go for a longer remedy? Why should you go for a longer remedy if you can sort it as now? Anyway, that is for another day. I'm not on a rally. Let me do what I'm supposed to do. So this is the ruling. The applicant in this matter was a candidate in the elections of directly elected member of parliament, Kalungu East constituency, that was held on 15th January 2026. According to the applicant, in the application presented by Council Kasangak Simon, he claimed to have polled 13,298 votes, and the respondent is alleged to have polled 12,832 votes, meaning that according to the applicant, according to Pamrangaki, he had won the respondent with a total of 466 votes. Contrary to his version, the applicant indicated to court that the respondent's votes were inflated by a total of 2,641 votes, and thereby got a total of 15,473 votes, upon which the returning officer declared him as a winner. The applicant indicated that he enjoyed overwhelming support and polled the highest vote, but his victory was robbed by electoral miscomputation that assigned him a genuine total of only 13,298 votes, and unlawfully assigned the respondent with a fictitious total of 15,473 votes. The summary of the application, according to the applicant, is that he had won Kalungu East parliamentary election with a vote margin of 466 votes, but due to miscomputation and unlawful inflation of the respondent's votes, the respondent ended up winning the votes with a fictitious margin of 2,641 votes, which votes, if counted, is said not to be in the box according to the applicant. Several photocopies of altered declaration of results were attached to the application, and the counsel for the respondent, I mean for the applicant, relied on them. An act that was vehemently rejected by the respondent's counsel as not genuine since they had not been certified. The applicant therefore prayed to this court that a vote recount under supervision of the Chief Magistrate Court be conducted in respect of vote cast in the election of MP Kalungu East constituency, particularly in the parishes of Bugozi, Kiti, and Mukoko of Bukurura sub-county, and Central Ward, Magezi Kizungu, Kaliro Ward of Rukaya Town Council in Kalungu East constituency. He also prayed for costs as well. In reply to the above, the application, Council Samuel Mulindwa Muizi, Alexander Rule, Zikso Kahabat for the respondent vehemently objected the applicant's prayer and advanced by Council Kasangaki Simon. They began by raising a preliminary objection that Masaka Court did not have jurisdiction as the matter had been filed in the G1 Court of Kalungu Court. Court overruled the objection because the application had been forwarded to the Chief Magistrate Court of Masaka by the Magistrate Grade 1, who is under the supervision of Masaka Chief Magistrate. The other objection that court dealt with was that Masaka Chief Magistrate Court did not have jurisdiction over the issue of election matters arising from Kalungu, and as there was an already Chief Magistrate Court at Kalungu, sitting at Kalungu. This objection too was overruled, and the court indicated to the parties that it was indeed common knowledge that the Chief Magistrate Court at Kalungu was not operational, and the decision to operationalize it was a preserve of the top management of the judiciary. The trial judicial officer also indicated to the counsel for the respondent that Kalungu Court was equally part of the handover as the jurisdiction under Masaka at the time of hearing the application. I beg your pardon. The trial magistrate also indicated to counsel for the respondent that Kalungu Court was equally part of the handover as a jurisdiction under Masaka, and at the time of her hearing the application, no contrary communication from the top management, particularly the chief registrar, had been received by the said judicial officer, who was in his second week at the station. In conclusion, court concluded that the application was before a right court and before a right judicial officer, and therefore had all the rights to preside over the matter. Counsel for the respondent argued that Electoral Commission and returning officers were supposed to have been added as respondents, being that they were in charge of organizing, conducting, tallying elections, and also declaration of the winner. Counsel submitted that the declaration of results forms cannot be relied upon without Electoral Commission and returning officer on board as respondent. He further submitted that Electoral Commission, electoral officials cannot be condemned for what they are said to have committed. I entirely agree with counsel for the respondent on this point that EC and returning officer cannot be condemned and heard as per several authorities cited by the respondent's counsel. I agree with counsel's submission because if Electoral Commission was made a party, they would have had opportunity to respond to the allegations made by the applicant and his counsel. However, on the other hand, counsel for the applicant submitted that the only way court can get to know the truth about the matter is through examination of all ballot papers and recounting, and thereafter recounting is done. It should be noted that court is alive to the fact that the store of Electoral Commission, where the said ballot papers are kept, have been under tight security ever since elections were conducted. Court was lucky to find the seal of the store. I want to be clear. Seal of the store, or where the ballot boxes are kept, intact at the time when it had gone to conduct a recount of the application arising from election petition of the elected member of Parliament of Kalungu West. And even after the exercise of sorting the ballot boxes of the said constituency, which is Kalungu West, court directed the Electoral Commission to continue protecting the store as a measure. And as a measure, a new seal was equally put until disposal of this application. This means that as long as the seal put on the store, as long as, I'm emphasizing that, as long as the seal we put last time remains untampered with, as the act of sealing the office was done in presence of all parties, though informally, it should be remembered that justice delayed is justice denied. Therefore, to delay this application would impliedly mean that the applicant will wait to file a petition in High Court after gazetting the respondent. And this means that Electoral Commission will remain under obligation of oversecuring electoral materials, yet a recount would solve the dispute quickly and less costly. Also, disallowing the application would maintain anxiety among the people and voters of Kalungu East and the state, where they are not sure of who their MP is. Therefore, considering the fact that election materials are in safe custody, the fact that the applicant claims that the respondent won with a fictitious vote margin that is not traced in ballot boxes, I find that a recount of all ballot papers, not some, ballot papers in ballot boxes of all polling stations is a solution. Therefore, I will proceed to allow it. The justification is that every participant in the election will be in a position to know how he scored in the parliamentary election conducted on 15th January 2026. I make no orders because according to the flow of counsel Kasangaki for the applicant, in advancing the reasons why application should be allowed, he indicated that irregularities, i.e. inflation of non-existing votes, was done by returning officer and her staff, yet they were never made party this application. Therefore, I cannot be seen condemning returning officer and electoral commission unheard. It should be noted that I cannot condemn the respondent because it was not his duty to tally the votes and later declare the winner. Therefore, each party in this matter will bear its own costs. It is further ordered that the recount of all ballot papers in ballot boxes of Kalungu East shall be conducted today, starting at 3. We had proposed to start at 2, but because of this, we need some time to have lunch and transit. Today at 3. To ensure that compliance is made to time stipulated by the law, this being the last 4th day within which to recount, within the meaning of Section 74, subsection 2 of Parliamentary Elections Act, i.e. within which a recount should be conducted. Before I take leave of this matter, I want to appreciate the efforts of men in uniform, the lawyers that appeared in this matter, for the professional submissions and for maintaining security at the store for elections. Even here, we wouldn't be safe talking. Kindly, to be a judicial officer, you have to apply, you advertise, they advertise, you apply, then you do interview. When you are appointed, you are then deployed. You wait for now, I'm the Chief Magistrate of Masaka. So I want to request, in regard to the experience and the allegations we had from council, I want to request or ask the regional police commander, the RDC as chairperson of security of Kalungu, the DPC of Kalungu to provide security to officers of court and the parties at the place where we are going to conduct our account. I also want to say this. I want to appreciate you men with cameras, and I want to appreciate you. And I want to encourage you to give accurate reporting. Some of you misspelled my name. I forgave you, but don't do it again. Yeah? I didn't have time to see what is transpiring here, but I want to request that do accurate reporting. We shall give you space, we shall give you time to see whatever is taking place, because what I'm interested in as a presiding chief magistrate is not only justice, but for justice to be seen to be done. I want to thank you and I want to wish you good journey masses to Kalungu, and at exactly 3 we shall begin the process, because past 5 council will not even need to make a submission if we cannot start recounting before 5. Then the count is over. Those who are so much attached to the agent and the candidates, you need to fast for 1 day by going without eating. The candidates, if you have not had heavy breakfast, forget about that. Move to the ground and you are. Let's meet in Kalungu.
Kale embeera eyo bwetyo bwekyali bagambye ebiva e Kalungu breaking news. Obululu bagambye Budibwemu bubali bukamtoka. Akanso bagenda kwogererawo oba embeera bweti bweri ku kooti e Masaka. Omulamuzi agambye obululu bw'e Kalungu East buddemu bubalibwe olwaleero ku ssaawa 9. The breaking news gyenyinza okubawa essaawa zino zennyini. Obululu biragiddwa bunnambiro buddemu bubalibwe mangu. Njagala funa bano bannamateeka aba omubaka Enkerettanyi Kiruluuta nga we mubalaba bali mu kufuluma kooti naye amawulire agaliwo Obululu bagambye buddemu bubalibwe. Kale ende n'abalala lawyers abibannyonnyole.
ne kakyuka byokoze wabweru w'amateeka byonna biba bifu era tugenda kuva wano tugenda mu kooti bwatyo Kasibante bwe bamukola ne sing kooti oluvannyuma erangirira Kasibante gwe bali bakoze bino because buli kooti weekola decision enkyamu bw'obalira mu decision enkyamu ne bwe bikyuka kooti eya waggulu kasita egamba nti wali mukyamu n'okutuzaayo eri kitegeeza result so bitulaga mu mbeera zonna tugenda Kalungu era nga bwetufayiringa ne mu high court. Yombi tugenda kuba nekyasebu kyebasitokera kiri kwaisi kubona kyera yasalawo mukyamu
bannamateeka bagenda kwogerako naffe bakyalinze bannamateeka abalala naye nga kyekyo ekiriwo yenze Abudu wa Bobi ku mukutu JB Muwonge TV yonna gye mundabira. Mayinja galagenda kusanga gye bagenda balira ngenda sooka nveeko soka enfune mmolo kubanga gye bagenda obbalira si wano si wano. Njagala bibannyonnyola nga tuvudde mu kubala, njagala bibannyonnyola kanso nze ne wetwogerayo nze ne tugenda oli live saawa zino bagala kumanya
ekiri e Masaka kaakati kooti etandise okuwa omulimu gw'okubala ordinarily mateeka nga wetugambye kooti nti bwebanga ebbanga lyetumaze emisango gy'ebyokulonda naddala egya recount okuviira ddala biseera bya ngoma njime 21 sirabangako decisions za kooti egamba nti yenna omuntu eyali mu Kalungu amaze okuwangulibwa yeetaaga kola kintu kimu kyokka kufayiringa recount oba application gy'akoze eri mu mateeka yes kyetulabye olwaleero bwe muddayo ne mwetegereza okuva muri kaunti gye zaatandikira mu 21 musango gwa Wini Byanyima n'engoma njime ogwali mu state influence ey'amaanyi tuzze nga tulaba kooti zeesigaliza obuyinza obw'okusalawo ensonga mu mateeka. Kyetulabye Masaka kaakati mu applications ebbiri ezakasalibwawo kooti eri mugamba kintu kimu omuntu yenna ali eyo ne bakubidde omulanga nga bakusinga mu kalulu kola kintu eki teekayo application ya recount kuba kooti eri mugamba mu nsala yaayo nti naye gwe balangiridde okweka ki mu bokisi ziri obutaddayo mu kubala yensala yokka terikozesezza amateeka wadde netteeka n'erimu tegenze mu submission zonna ze tukola evudde mu bwa kkooti nedda ebyebufuzi kikye tugenda okukola bino ebintu ebimu tubikola si lwa mata eriwo kaakati okulwanira ebyobufuzi okugjawo embeera nti kati kkooti yegenda okutandika okulonda okusalawo n'okubala obululu kuba ekisooka si mulimu gwa kkooti okubala obululu bw'ayagala obululu bwe baddemu babubale bw'olina okulaga kkooti nti mbubokisi efaanana bweti obululu bwange tebabubaze bulungi era nsaba obuddemu ne kaakati omuwaabi yasaba na bokisi ntono n'agamba zino bokisi ze ziriko ekizibu kkooti egambye tegenda nakukoma ku bokisi oyo zatasaba esazeewo okubala mu Kalungu East constituency konna Budibwemu kiri wabweru w'amateeka essaawa eno newankubadde tugenda e Kalungu neera ne kaaka tugenda kufayiringa revision eringa appeal okuva mu nsonga zino ebbiri newankubadde the Honorable Sewungu okubala obululu tekwagenze mu maaso naye kennyini asazeewo ajulire tusobole okufuna kkooti okutereeza ensala za kkooti ento kijjewo embeera y'okuba nti ebyokwesimbawo n'ebyokulonda n'ebyokubala abalulu akalulu bakabalira ku polling station bwe baba ku polling station ne badda ku ttale center kati ebyo byonna kkooti ebizinzeeko mwali mumala budde okuggyako okulonda kwe mwakola esazeewo okubala obululu kubeere kwayo mu Kalungu East ng'abala akalulu ye presiding officer ng'aliwo yekka ye mulamuzi kubanga ne electoral commission ne returning officer teriiwo kubanga tebagireeta mu kkooti tulowooza nga bannamateeka nga bwe mulabye kkooti tulina obuvunaanyizibwa obussa ekitiibwa mu kkooti era kkooti tugiwadde ekitiibwa kyayo neera tulina obuvunaanyizibwa obuwakanya ekikyamu tugenda kuwakanya ekikyamu nga tugenda mu kkooti ensukulumu ebigenda mu maaso e Kalungu olwaleero n'ebinaavaamu nga oyo yasaba kkooti yawangudde bwe biba nga kkooti ebituuseeko wabweru w'amateeka kkooti enkulu egenda bisazaamu nga bwe kyali mu musango gwa Kasibante ne Katongole Singh kkooti yagamba ensukulumu nti ekkooti si ze zibala obululu era olw'obukyamu bwe bayitamu nga kkooti obukyamu bweyiseemu bwe yasazaamu decision y'okubala obululu okwali kututte Katongole Singh mu palamenti yazzaayo Kasibante mu palamenti era bwe kityo kye tugenda okusaba nti ebigenda mu maaso nga tubifuddeeko ensala eyabadde mu musango gwa the Honorable Sewungu newankubadde tebaabaze erina okusazibwamu ensala egenze mu maaso olwaleero musango gwa Nkerettanyi mu mateeka erina okusazibwamu era bw'enaasazibwamu tusuubira obuwanguzi bw'abalonzi n'okubala obululu bwabwe kujja kuddizibwawo kkooti ensukulumu This is unprecedented. We've participated and seen recounts since 2001. This court has wished away all the jurisprudence in recount matters. It has decided matters not on points of law, not on matters of fact before it, but on matters of opinion by the presiding chief magistrate. Because in his own opinion, every recount which should come before him will go into a recount, irrespective. The presiding chief magistrate is of the opinion that why would a candidate refuse to go to the boxes? That's the justification. The interpretation of that is that everyone out there, even my colleague here, Herbert Zikshoka, who was a candidate in Chimanya Kabonera, provided he comes back to court here, files an application, whether outside time or within time, the court will take them back to the vote recount. That is absurd. It is unprecedented and we are going to reject. We are duty bound as officers of court to respect decisions of court. And we have to respect court. Indeed, we are very respectful to court. That's why we are obliged to look at its decision and respect it. But we are also enjoined to reject a wrong decision. We have been instructed by our clients, both the party, the National Unity Platform, and both the Honorable Sewungu and Honorable Keretanyi, to file an appeal by way of revision in the High Court to determine and streamline the way recounts have to be adjudicated. It is wrong at law, wrong at fact, that a judicial officer does not follow the law, but by his own opinion. It is an injudicious decision. It will not stand. The effect of our application for revision. You recall, in the matter between Kasibante Moses and Singh Katongole, in a similar way and fashion, a recount was conducted by the Chief Magistrate, which returned Katongole Singh Marwa as the newly elected MP. By court, the Court of Appeal, the High Court overturned that decision, with the result that the people of Lubaga did not have to go back to the election. But Katongole Singh was declared an invalidly determined Member of Parliament for Lubaga North. We believe that is the result. It does not matter that the Honorable Sewungu's recount did not proceed. It only matters that we cannot continue having courts usurp the rights of the people to elect their leaders. You cannot say that every person who raises his hand in a recount will succeed into that recount. Secondly, the applicant requested for a given number of ballot boxes. So the determination was supposed to be limited to those number of ballot boxes. But that the court went outside all the pleadings, all the submissions by the applicant and respondent, and arrogated itself a duty of recounting all votes which are counted at the polling station. It is wrong at law. It is a wrong decision, which we are going to appeal against by way of revision in the High Court.
Kale embeera bwetyo bweri yenze Abudu wa Bobby. Kale tolekedde ate Kalungu ku Electoral Commission oba ku Tale Center gye balangirira akalulu kano aka Kalungu East ne West oba Kalungu District yonna gye tolekedde gye bagenda okuddamu okubala Obululu oba okuddamu okubala akalulu akawangulwa munnakibiina era yakwatira NUP bendera mu kalulu akabonna aka 2026 Honorable Keretanyi Yusufu bwe yali ne munne minisita yaliko minisita Sempijja bamulanga ki mu bitundu bino ebya Kalungu. Omulamuzi abasindise e Kalungu ku ttale njagala ntuukeyo mbeerewo mu kubala kwonna ngenda kuba mbi batuusaako byonna live. Tusooke tugende kuba waliwo akagendo okutuuka e Kalungu we bagenda okubalira n'essaawa 9 bagenda kuddamu okubala akalulu. Yenze Abudu wa Bobby kwa JB Muwonge twekuumire ku JB Muwonge tulabe ye Obululu babala butya babubala butya era biggwa bitya. Wekuumire ku JB Muwonge tuli Kalungu.